Yes, Mr. Wilson.
Yes. My lord, during lunch, my lord, I have further, my lord. So what I am arguing now, my lord, is further abridged edition, my lord.
Yeah.
My lord, I was on para 19. The argument, however, was that the word industry was a word of wide import and should be construed as including not only the process of manufacture and production, but also activities antecedent thereto, such as acquisition of raw materials, subsequent thereto, such as disposal of finished products of that industry. The process of acquiring raw materials was an integral part of industrial process and was, therefore, included in the connotation of the word industry. And when the central legislature was invested with the power to legislate in regard to sugar industry, which was a controlled industry, it should be scheduled industry, by entry 51, list 1, that legislative power included also the power to legislate in regard to the raw material of the sugar industry, that is sugarcane, and the production, supply, and distribution of sugarcane was, by reason of its being necessary ingredient in the process of manufacture or production of sugar, within legislative competence of the central legislation. Each entry in the list, which is a category of head of the subject matter of legislation, must be construed not in a narrow or restricted sense, but as widely as possible so as to extend to all ancillary or subsidiary matters which can fairly and reasonably be said to be comprehended in it. Thereafter, your lordships may kindly come to, my lord, just above para 21, what we are concerned with, my lord. Your lordship gets, my lord. What we are concerned with here is not the wide construction to be put on the term industry as such, but whether the raw material of an industry which form an integral part of the process are within the topic of industry, which forms the subject matter of item 52 of list 1, as ancillary or subsidiary matters which can fairly or reasonably be said to be comprehended in that topic, and whether the central legislature, while legislating upon sugar industry, could, acting within the sphere of entry 52 list 1, as well legislate upon the sugar cane. If both the central legislature and the provincial legislature were entitled to legislate in regard to this subject of production, supply, and distribution of sugar cane, there would arise no question of legislative competence of the provincial legislature in the matter of having enacted the impugned act. The conflict, if any, arose by reason of the interpretation which was sought to be put on the two entries. Entry 62 of list 1 and 27 of list 2 put in juxtaposition. 62 is a typo, my lord. It should be 52. Put in juxtaposition with each other. It was suggested that item 62 of list 1 comprised not only the legislation in regard to sugar industry, but also in regard to sugarcane, which was an essential ingredient of the industrial process of manufacture or production of sugar, and was therefore ancillary to it and was covered within the topic. If the legislation with regard to sugarcane thus came within the exclusive province of the central legislature, the provincial legislature was not entitled to legislate upon the same by having resort to entry 27 of list 2, and the impugned act was therefore ultra vires the provincial legislature. My lord, rest your lordship can skip. Some judgment is cited. Kindly come to, my lord, para 22, after the quotation, my lord, in Subramaniam Chettiar. Am I with your lordship?
Yeah.
And it was contended that entry 27 of list 2 should be construed in a general manner as applying to production, supply, and distribution of goods in general. And entry 52 of list 1 should be construed as comprehending within its scope ancillary matters in relation to the controlled industries, thus excluding production, supply, and distribution of goods, which would be thus comprised within it as ancillary matters from the sphere of entry 27. The argument was that read state entry in a wider sense and the central entry 52 in a restrictive sense. If this construction was adopted, it would avoid the apparent conflict between the two entries and would reconcile the power of the provincial legislature with those of the central legislature. It was therefore contended that the legislation in regard to sugarcane should be considered as ancillary to the legislation in regard to sugar industry, which is a controlled industry and comprised within entry 52 list 1 and should be excluded from entry 27 list 2, which should be read as covering only those categories which did not fall within entry 52 of list 1, even though on a wide construction of the word production, supply and distribution of goods, they would be capable of covering the same. If this construction was put upon these two entries, it would follow that the subject matter of the impugned act was within exclusive jurisdiction of Parliament, being comprised in entry 52 list 1 and was ultra vires the UP state legislature. The answer of the state of UP was twofold. One, after the advent of Second World War, my lord, your lordship can skip. Two, that the impugned act merely confined itself to the legislation in regard to sugarcane and did not purport to legislate in regard to sugar, which was exclusively dealt with by the centre. There was therefore no trespass upon the exclusive jurisdiction. My lord, 23, your lordships can skip, my lord. Just, my lord, above 24, sugar and sugarcane thus, my lord, your lordships can. That also your lordships can skip, my lord. It's interplay between essential commodities act and sugar, my lord. Nothing would assist your lordships, my lord. Para 24 is the finding. It is clear, therefore, that all the acts and the notifications issued thereunder by the centre in regard to sugar and sugarcane were enacted in exercise of the concurrent jurisdiction. They don't, my lord, say 27, they resort to 33. The exercise of such concurrent jurisdiction would not deprive the provincial legislature of similar powers. This is the ratio which they had under the provincial legislative list, and there would therefore be no question of legislative incompetence qua the provincial legislature in regard to similar pieces of legislation enacted by the latter. The provincial legislature as well as central legislature would be competent to enact such pieces of legislation, and no question of legislative competence would arise. It also follows as a necessary corollary that even though sugar industry was a controlled industry, none of these acts enacted by the centre was in exercise of its jurisdiction under entry 52 list 1. Industry in the wide sense of the term would be capable of comprising three different aspects. Please mark this, my lord. One, raw materials, which are an integral part of the industrial process. Two, the process of manufacture or production. And three, the distribution of production of the products of the industry. The raw material would be goods, which would be comprised in entry 27 of list 2. Look, this is where in my submission, my lord, there is an error in law. If the first part is right, then industry encompasses everything from raw material to supply and distribution of final product.
Section 2.
May I, my lord, continue reading?
Yes.
The raw material would be goods which would be comprised in entry 27 list 2. The court is not, my lord, invited to see entry 33 here, that it is in entry 33 also.
That's in the next sentence. Then.
The process of the process of manufacture or production would be comprised in entry 24 of list 2, except where the industry was a controlled industry, when it would fall within entry 52 of list 1, and the products of the industry would also be comprised in entry 27 of list 2, except where there were the products of control industries, where they would fall within entry 33 of list 3. This being the position, it cannot be said that the legislation which was enacted by the center in regard to sugar and sugarcane could fall within entry 52 of list 1. Well, this is under the Essential Commodities Act, not my lord IDRA. Before sugar industry became a controlled industry, both sugar and sugarcane fell within entry 27 of list 2. But after a declaration was made by Parliament in 1951 Act, this is IDRA, that is by Act 65 of 51, sugar industry became a controlled industry, and the product of that industry, that is sugar, was comprised in entry 33, list 3, taking it out of entry 27 of list 2. Even so, the center as well as the provincial legislature had concurrent jurisdiction in regard to the same. I have no difficulty. That is so. In no event could the legislation in regard to sugar and sugarcane be thus included within entry 52 of list 1. This is wrong, in my respectful submission. It's a scheduled industry. 52 provides for a declaration. Declaration is made that these industries will fall within 52, and therefore the Parliament did it. The pith and substance argument also cannot be imported here for the simple reason that when both the center as well as the state legislatures were operating in the concurrent field, there was no question of any trespass upon the exclusive jurisdiction vested in center under entry 52 of list 1. Only question which survived being whether, putting both the pieces of legislation enacted by the center and the state legislature together, there was any repugnancy, a contention which will be dealt with hereafter. This is what the question was. But your lordships would find, my lord, there is no reasoning, discussion or finding why sugar or sugarcane cannot be a part of a legislation under entry 52 list 1. It can be, my lord, declared by the Parliament to be an industry which needs control by the central government. The court proceeds on a footing that it falls only under 33, and 33 being concurrent, both have the jurisdiction. Now we will examine whether there is any repugnancy. Now further.
No, entry 33 is also having a relationship with entry 52.
52, even 27 has a relationship, is subject to 33.
So it is not before entry 52.
In fact, if there was no entry 33 in list 1, those products should fall under entry 52 of list 1.
Yes.
Isn't it?
Yes.
If there was no entry 33.
Would have exclusively to the center, my lord. Now, my lord, a more...
That threefold dichotomy between raw material, manufacture and products, that may not be, as a matter of abstract proposition, that may not be correct. Now, products are separated out by a constitutional entry. But that constitutional entry indicates that but for it, the product should have gone to entry 52 of list 1, probably.
I'm grateful.
And raw material can be...
I'll show. They'll remain in the state list otherwise. But please see, word industry emanates from the state list 24. Now, when we demarcate the field of industry, whether it is taken over or not, then we have to notice the other comparable entries. Now, what happens is, Lord, if industry comes in 24, then the product goes to 26, 27. And if raw material, if it is good, as the judgment says, and it is not, electricity is a good which we can't even see. Telecom signals are...
When a product would be a good, my lord, final
so
product
raw material also goes in entry 27, which means deals with goods.
But 27 is subject to 33. My lord, the question, but my learned friend has put a wrong question. The question should be, why should it not fall under 52? Suppose 33 would not have been there, entirely, exclusively under 52. Now 33 means you have to exercise central power and concurrent powers. And both would oust, when exercised by the Parliament, the state legislature. No, that's the, in my respectful submission, the correct rationale. But that is, my lord, missing.
That's why it is called clause 3 is subject to clause 1 and 2 under article 246. It is subject to.
Correct. My lord, 25. A more effective answer is furnished by the comparison of the terms of UP Act number so and so with those of impugned Act. Whereas, my lord, now they compare both the acts, my lord, with which we are not concerned. They said there is no repugnancy because both operate on separate fields. Why? One deals with raw material, another deals with only manufacture. Now, my lord, 25, last para, my lord. Just above 26. This comparison, your lordship gets one.
Yes.
This comparison goes to show that the impugned act merely confined itself to the regulation of the supply and purchase of sugarcane required for use in sugar factories and did not concern itself at all with the controlling or licensing of sugar factories, with the production or manufacture of sugar, or with the trade and commerce in and production, supply and distribution of sugar. If that was so, there was no question whatever of its trenching upon the jurisdiction of the center in regard to sugar industry, which was a controlled industry within entry 52, list 1, and the UP legislature had jurisdiction to enact the law with regard to sugarcane because they bifurcated raw material.
So, Mr. Solicitor, your argument is that then entry 52 is broad enough to include even the products.
Read with 33.
Read with 33.
Yes. Now, my lord, further. Then your lordships may, my lord, kindly see. Now, my lord, they could have, my lord, possibly stopped at that, but please come to page 31. Para 31, I'm sorry, my lord. My lord, this is reliance upon para 30, my lord, first. Suleiman J. in Shyamkant Lal versus Ram Bhajan Singh. And at the foot, what they rely upon is Attorney General for Ontario versus Attorney General for Dominion. My lord, it's on record, but I'm not reading it. I'll just orally point out, my lord, how that judgment is completely not relevant or, my lord, in facts of the case. Now, what happened in Ontario? Now, Ontario is a province in Canada. My lord, your lordships are aware, my lord, my lords are aware, our 254 is, my lord, inspired by section 109 of the Australian Constitution. It is peri materia. So provisions are peri materia. My lord, I'll give, my lord, Ontario, my lord, in Indian parlance, my lord, so that it's easy for me to make myself clear. My lord, India has a law, take it as a Canadian law. The law says that the law is in two parts. One part, how to deal with a particular commodity, say alcohol. Second part of that central law says whether the state would accept this law or not, the state would decide. For example, Karnataka would decide whether this central law would be applicable in Karnataka or not. How chapter 2 dealt with that there would be a meeting held, there would be a voting take place, and by majority, if they take a decision that we will accept the central legislation, the central legislation would apply to Karnataka, which was, my lord, Ontario in this case. Here, there was no such meeting took place. So central law was not applicable, and Ontario law on the very same subject enacted a law, Ontario being the state. Here, in my example, Karnataka. And therefore, when the question of repugnancy came, the High Court of Australia, which is the highest court, my lord, said that there is no question because in fact, there is no repugnancy because the law is not made applicable. The central law does not apply to Ontario. So that is the long and short of this judgment. But what has happened is, my lord, in Shyamkant Lal, one line is picked up. Somebody has cited that repugnancy should be in fact and not merely based on a possibility. Lord, in the instant case, how, my lord, the Tikaramji judgment refers that there is no notified order. So there is a possibility of a notified order. In absence of notified order, there is no question of your applying the central law. Lord, my worry is this. If this logic is right, then all enabling central acts, which enables the central government to do something or not to do something, will become repugnant if the central has chosen not to do something, because they are only enabling, they are not mandated that you will have to do it. Center is enabled, central is empowered to do something. Now in this context, see para 31, which, my lord, in my submission never fell for consideration. In the instant case, there is no question of any inconsistency in actual terms of the acts enacted by Parliament and the impugned act. The only question that arises are whether Parliament and the state legislature sought to exercise their powers over the same subject matter, or whether the laws enacted by the Parliament were intended to be a complete, exhaustive code, or in other words, expressly or impliedly evinced an intention to cover the whole field. My lord, this is, my lord, ultimately the law. Your lordships have also, my lord, used the same expression in forum. It would be necessary, therefore, to compare the provisions of Act of 65, that is IDRA, as amended by so-and-so, and the Sugar Control Order issued thereunder with those of the impugned Act, that is State Act, and UP Sugar Regulation Act. Now, your lordships will kindly come to which is that.
But is overruling Tikaramji really crucial for your line of submissions?
Malad, not the reason, Malad, why Tikaramji, Malad.
Tikaramji, you are really concerned with that threefold bifurcation which they do of manufacture.
And restricting, Malad, I'll just restrict.
Manufacture, raw materials, and.
Malad, para 32 troubles me. And, Malad, this notified order, para 32. Malad, please see para 32. Only para 32, Malad. At 102, Malad. Where's the relevant portion of para number? 97, I'm sorry, 105.
Because, Mr. Solicitor, at a certain level, I'm not sure whether you can say that Tikaramji is an egregious error or anything like that. Because, see, products are separated out of the industry. That's very clear. In relation to list 2, products go to 27. The industry is under 24. The goods come under 27.
Which is subject to 30.
Of course. But 27 is an indicator that the products don't go with the industry. Some products of controlled industries, declared industries under entry 52 of list 1, go under clause A of entry 33 of list 3. So this much is clear that there is a separation of the industries from the products. They either go in respect of state industries, state-controlled industries into entry 27.
In unregulated or
union industries, I'm just using that loose expression, under entry 52, the products go to entry 33. So now the only question is that there they to sustain the State Act. They said that, look, the State Act dealt with the raw material, which was sugarcane.
Beyond that, my lord, what is my trouble?
For us to overrule, I mean, your argument may be sustained even on independently of the correctness of.
Lord, the difficulty is the reference order says that synthetics 2 didn't notice Tikaram. And Tikaram, my lord, therefore it becomes necessary. My lord, please see why I have two problems with Tikaram.
But how does Tikaram, assuming that the reference, synthetics didn't notice Tikaram, synthetics sustains your position. Suppose synthetics had noticed Tikaram, would that make any difference to you?
I don't think so. Except, my lord, please come to, my lord, page 105. I have two problems.
I mean, it's because these are older judgments which have stood the test of time.
No, only two problems with Tikaram. Only two problems with Tikaram.
Is there no, see, you can always explain away some observation in a judgment.
Yes, my lord, your lordships can do that. Lord, if your lordships can come to
a judgment which has been followed in our own jurisprudence, you don't know what the large-scale impact would be.
No, certainly, my lord, if your lordships can come to para 32, यहाँ पे है, the raw material
irrelevant.
Your argument that the field is not occupied unless there's a notified order, because 18G uses the expression notified order. That we'll deal with separately.
Correct, my lord.
But I'm just trying to see, you may reflect on it, even after you finish today, in a little while, you can still reflect on it, because that is it strictly necessary for us to start, wielding the axe and go in, overruling an earlier judgment like
It will
this?
be not my-
Or can we not?
my friend.
Can we not? I mean, we have to hear the petitioners in rejoinder. Can we not independently, or can you not independently sustain your argument even without going to Tikaram?
Before a larger bench, my lord. The honorable 9 judges would not be bound by Tikaramji, my lord. Whether your lordships overrule, explain, or whatever, my lord, your lordships can definitely take a different view. But my difficulty is one.
Suppose we say that we just cite Tikaram without either overruling it or saying
I
that.
have no, my lord.
But that's why we are asking you, can you not sustain your line of inquiry or your argument irrespective of the correctness of Tikaram? Or are you in a situation where you have to confront the correctness of Tikaram, otherwise your argument has to be rejected
Lord,
by
if your lordships are persuaded that raw material does not fall within the term industry, A, industry includes only manufacturing, B, and third, in absence of a notified order, there is the field open and the state can
Okay,
live.
let's see that notified order bit of Tikaram. That is para 32, right?
Lord, only, my lord,
Let's
for
see how
my
it deals.
satisfaction, my
My
lord, page
request,
105.
Lord, may I request lordships not just to pause for a moment. I'll add on to what my friend is saying. Tikaramji is essential for the reason, Lord, that the alcohol which is subject matter of dispute in synthetics 2 is product of the notified industry, because IDR specifies alcohol industry. So taking it as a product of the notified industry, and the question is sale, distribution, etc., will go where? Because that was a case involving fee being charged for
Go to entry
vending.
33 of list 3.
I mean,
It will go to entry 33 of list 3.
exactly. So then therefore, Lord, the question inevitably arises, is there a law made under section 18G? Because 18G is traceable to, I'll show.
So the only point then which suffices that even if the product of a declared industry goes into entry 33, there is no notified order. That's the only point which we have to still hear Mr. Solicitor on that.
And, my lord,
Lord, if my friend permits, both the submissions will survive. Second, because synthetics further says that it cannot fall under entry 8. So therefore, we'll have to raise that argument that entry 8 includes industrial alcohol.
but Tikaram is not on that. So,
I'm not. Tikaramji is essential because...
Whether entry 8 includes industrial alcohol or not is a separate issue. That we have argued, yes.
So therefore, synthetics has to be seen in the context of both the issues.
No, whether intoxicating drinks under entry 8 includes denatured spirit, we have to deal with. There's no difficulty.
Yes.
But I'm only on this, instinctively as a judge, sitting in a combination of 9, because you don't know what the unforeseen, we are looking at it from the point of view of industrial alcohol. As Sister Nagaratna was also saying a moment ago, Tikaramji must have been followed throughout in our jurisprudence.
Yes.
We don't know what we will be answered if we just go, hammer and tongs at
no,
Tikaram.
certainly. But I bow down to that. But I am not in an adversarial...
Therefore, Solicitor, yeah, that's exactly.
But I will show.
Just see, on the notified order, you can make your argument now, but you can just reflect on it. Maybe just tomorrow is a holiday. You can reflect on it and tell us in 5 minutes day after. Suppose we don't decide to reconsider the correctness of Tikaram. Can you not still sustain your argument on without going into the correctness of Tikaram?
Except that Tikaramji restricts... I'm sorry.
18G. 18G, then you will have to deal with the argument.
Yes. No, Tikaramji restricts the meaning of the word industry to be only manufacturing.
But see,
now the problem.
But Solicitor, insofar as industries of the states are concerned, entry 24, the goods go into entry 27 anyway. So whether it's under 24 or 27, they have authority of the goods. Products of a controlled industry, the declared industry under entry 52, it goes into your power under entry 33, albeit a concurrent power. And there your argument is that, look, but IDRA is comprehensive enough and has occupied the field. If you are right.
My submission. I'll respond. And if
reflect on it, because
I'm not right now, taking a lot.
We are a bench of 9. We are untrammeled.
Certainly.
At the same time, when there is a long line of authority which has stood the test of time, it's easier for future benches to distinguish it, say it's not applicable, these were the peculiar facts. Suddenly saying, that it's overruled, it's like,
Just to save time.
a certain parties not the ratio. Says, Brother Oak says that some part is not the ratio decidendi.
That's my submission.
Necessary. Articles. That's right.
Section 15 and section 16. So the bench says when you talk of articles, you mean the manufactured product and not the raw material that goes into the article. That's how they say, please see the explanation to 18G also. Article or articles, class of article or articles. So what Dikaramji says is when you refer to articles, it means the product which is made, not the raw material.
That's paragraph 32.
32.
Yes, but it
Let's
misses.
32 once again. There's that part. Let's see 32 for a minute.
But my lord, only bear one factor in mind while reading 32. 18G says article or class of articles relatable to any schedule industry. Not touched at all, my lord, in Tikaramji. Now 32.
Find it.
Act 65 of 95.
The expression goods includes materials and articles. Under Article 366(12), it includes materials and articles. Both are included.
Yes, yes.
And goods is under entry 27, subject to entry 33 of list 3.
Correct, my lord. My lord, please see 32. Act 65 of 95, 51, that is IDRA, was an act to provide for the development and regulation of certain industries. My lord, your lordships can skip that. Kindly come after 18, my lord, before that, my lord, just above 18G. It did not involve the regulation of the supply and purchase of sugarcane, which, though it formed an integral part of the process of manufacture of sugar, was merely the raw material for the industry and as such not within the purview of the act. This is, my lord, the finding. My lord, tomorrow, my lord, suppose for a defense industry, I am giving a loose example. The central government is required to control the raw material, which is some mineral, some typical mineral, my lord, which is used for producing some defense equipment or some substance. We cannot do that. That will have to be the state's legislature. The center would depend upon the state. And 52 is intended to be an overarching provision that for some industries, uniformity requires the center only to have the power. Then, my lord, further, the act had remained as originally enacted. The provisions of the act would not have been in any manner whatever repugnant to the provisions of UP Act, because both the acts covered different fields. Act 26 of 1903, however, introduced certain amendments. Then, my lord, 18G is quoted, where relatable to any schedule industry is, my lord, specifically added. Thereafter, the court says, sugar industry being one of the schedule industry, it was contended for the petitioners that sugarcane was an article relatable to the sugar industry and was therefore within the scope of section 18G of the central government, was thus authorized by notified order to provide for regulating the supply and distribution thereof and trade and commerce therein. If that was so, it was next contended the field of legislation in regard to sugarcane was covered by this provision of the Act and was taken away from the jurisdiction of the state legislature. The avowed intention being to cover the whole field of legislation. It was, however, urged on behalf of the state that articles relatable to schedule industry comprised only those finished products which were of the same nature or description as the article or class of articles manufactured or produced in the schedule industry and did not comprise the raw materials. This, my lord, is not coming out, my lord, of the bare reading of the section for the schedule industry. Reliance was placed in support of this contention on terms of the explanation to section 18G as also section 15 and 16, where the same words, any article or class of articles related to that, relatable to that industry, were used. In our opinion, the contention of the state is sound. The structure of the whole Act 65 of 51, that is IRDA, related to development and regulation of scheduled industries and all provisions which were contained in the Act, including those which were introduced therein by Act 26 of 53, were designed for effectuating that purpose. It is significant to note that even in Section 18G, the regulation which was intended was that of the supply and distribution of article or class of articles relatable to the scheduled industry, and the production of those articles was not sought to be regulated at all. The raw material would certainly be essential ingredient in the process of manufacture or production of the articles in the scheduled industry, but would not be the same nature or description as the article or class of articles manufactured or produced therein. The whole object of enactment of Section 18G was to secure equitable distribution and availability at fair prices of such articles which, by relation thereof to the article or class of articles manufactured or produced in the scheduled industry, would affect such manufacture or production or the supply and distribution thereof or trade or commerce therein. Lord, kindly pause here for a minute. Lord, I have shown the provisions of IDRA which says that even price control is one of the regulations. If we want to control the price, we will necessarily have to control the raw material price, or ensure that the raw material is not sold for any other purpose other than the purpose for which, my Lord, we are regulating. Not considered. Not only were the article or class of articles relatable to the scheduled industry, which were themselves manufactured or produced in this country, but not necessarily, it can be mineral, it can be sugarcane, it can be any grain, agricultural produce, sought to be controlled in this manner, but also the articles or class of articles imported into India, which were of the same nature or description as the article or class of articles manufactured or produced in scheduled industry, so that all these articles, whether indigenous or imported, would be controlled by the central government by regulating the supply and distribution thereof and trade and commerce therein, with a view to develop and regulate and thus control the scheduled industries in public interest. Section 15 of the Act provided that where the central government was of the opinion that in respect of any scheduled industry or industrial undertaking there had been or was likely to be a substantial fall in volume of production in respect of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking for which, having regard to the economic condition prevailing, there was no justification, it may make or cause to be made full and complete investigation into the circumstances. But Lord, suppose the raw material production started falling, the government can inquire into it, my Lord, in a given set of facts, that why raw material has started falling. As a result, the production has started getting affected. If after making or causing to be made any such investigations, the central government was satisfied that action under Section 16 was desirable, it was to issue such directions to the industrial undertakings concerned as may be appropriate for regulating production of any
Para 32 of Tikaramji, that's a little bit of a problem.
It's an obiter, my lord.
And
according-
that's an obiter. We can say that they were not called upon to really decide that.
Decide that.
And actually, that may not be a correct approach also, because they say repugnancy must exist in fact and not depend merely on a possibility. There are two ways in which the conflict has to be addressed under the concurrent list. One, where the central law says something and the state law mandates exactly to the contrary.
Can't coexist.
They both can't coexist. The second may be where the central law, by virtue of the comprehensive nature of its provisions, excludes any legislation by the state. If I was just telling my colleagues, our judgment in that West Bengal RERA case, West Bengal HERA
That is
case,
forum.
forum,
Forum.
where the state law was identical to the central law.
Yes.
And the argument of Mr. Dwivedi in that case was that, look, what have we done? We have enacted a law which is identical to the central law. Where are we barred from making a law which is identical to the central law? That was the argument of Mr. Dwivedi, Mr. Rakesh Dwivedi. We overruled it and set aside the state law, saying that, look, once the central law,
Occupying the
RERA has held a field, the state cannot enact a law even on all fours with the central law. So, repugnancy in the sense that, they can't both stand together is one aspect of repugnancy. And this part about 18G, the notified order, there may be a way out of it. You see, 18G confers power on Parliament to regulate production, supply, distribution, etc. By a note, and says 18G says that the central government may, by a notified order, provide XYZ. Now, the issuance of a notified order is an administrative act. This cannot be determinative about the field which is occupied by Parliament.
Absolutely. My lord, in Mariyar Prem, this exactly was the situation. But I'll just give me 2 minutes. But I'll not
So
cite.
now we've seen this para 32. What do you want to see show us in Tikaramji so that we
But
can
this
then
is all.
wrap
My
up?
lord, Tikaramji is over.
think,
Tikaramji judgment is over. My lord, we have Talak doubts Tikaramji.
Which one? Who doubts it?
Talak, my lord. My lord, if your lordships can.
Tilak.
First, my lord, it is doubting in Hingar Rampur, my lords. Hingir Rampur, I'm sorry, ma'am. Hingir Rampur, we have cited in minerals matter and bench was same, so I'll not read them. Thereafter, my lord, I have, if my learned friend can, my lord, we have prepared a list of follow-up judgments of Tikaramji, my lord, if 4I.
अब हो गया 4 आया क्या अभी नहीं आया
So, look, my lord, I have page 78 of my written submission. I have quoted para 30.
Only that has to.
Let me give the para numbers only, my lord, how it is followed. I'll without reading it, my lords.
para
Page 78.
Give us the citation first.
Yes, my lord. It is, I'll give the Hingir Rampur first, my lord. Hingir Rampur is, because it was first doubted in Hingir Rampur. Page 80, para 92 of my written submissions. I have quoted, my lord. Therefore, your lordships may get a immediate
page
uh,
page 82
80.
Volume?
2D
80, my lord. Hingir Rampur, my lord, the citation is 1961, volume 2, SCR 537. And if your lordships would like to go through the whole judgment, my lord, it's on record. On that page 80, my lord, we have given the citation, PDF volume 5F, page 409. Then to law, I'm sorry, my lords. So Tulloch is page 78, para 91. I have quoted, my lord, para 13 in extenso. Citation is, it's a, my lord, 5-judge bench judgment again, 1964, volume 4, SCR 461. It is same volume, volume 5, capital B, page 113.
The earlier one was page 5F, no, you said.
5B, volume 5B.
Hingirampur was volume.
Ingir Rampur is 5F.
Yeah, and Tulloch's is volume 5B.
5B, page 113. Para 13, which is quoted in my written submissions at page 78, 79 onwards.
The test of two legislations containing contradictory provisions is not, however, the only criterion of repugnancy. For if a competent legislature with a superior efficacy expressly or impliedly evinces by its legislation an intention to cover the whole field, the enactments of the other legislature, whether passed before or after, would be overborne on the ground of repugnance. Where such is the position, the inconsistency is demonstrated not by a detailed comparison of provisions of the two statutes, but by the mere existence of the two pieces of legislation.
Yes, that's what your judgment says. Now this dual.
Look, there is one judgment, my lord, of Andhra Pradesh High Court, my lord.
93.
Para 93, page 81.
Look, there is one judgment of Andhra Pradesh High Court by Justice B.P. Jeevan Reddy, my lord. But again, Andhra Pradesh High Court, my lord, that is 1988 SCC Online, AP, Andhra Pradesh, page 129, which is quoted in page 75,
AP page,
129,
where do we find it?
page 75 of my written submissions, my lord, 2D, volume 2D. And judgment is volume 5K, page 2. Entire judgment, but the relevant paragraph, entire, my lord, in 3 pages, my lord, I have quoted. Where Tikaramji is doubted, but ultimately the court takes a different route, my lord, and obviously, my lord, High Court could not have.
Or in the nature of arbiter.
It's that, all right.
Even arbiter would be binding, my lord. That. So it notes and says that this.
Arbiter. Notes and says that.
Because Raghupathi says, even assuming
That's
last para 32
right.
is saying even assuming.
That it
should have been
issued. That's right.
It was not called upon to decide, but said something.
The act of federal act. That was the first of last sentence.
Notification. That's
So
right.
no discussion. But otherwise, my lord, what happens is, my lord, what happens, my lord, the ratio in Mariyar Prem, my lord, is this. Mar Apriyam. Mar Apriyam.
He will not be able to pronounce it.
Mar Apriyam, my lord.
We'll make Mr. Dwivedi also make a try at it, you see.
I would not like to attempt even.
My lord, there, the court had beautifully said, my lord, their argument was, as I have indicated, act was passed.
Yes.
Assented to by the President of India. At that moment, law is made as contemplated under Article 254(1). It was not brought into force. So there is always a commencement date. It would commence from the date it is notified by the central government. Well, the court said that it is a law made by Parliament, assented to by the President of India. The existence of the law cannot depend upon an executive action or inaction of not bringing it into operation. So therefore, it is a law, and if it is in conflict with some other state law, repugnancy will have to be tested. It's a constitution-based judgment.
Yes, Mr.
Lord, that is, my lord, I'll just give the citation on this, my lord, obiter part, my lord, page 82 of my written submissions, my lord. Para 94, State of Kerala versus Mar Apriyam Puri Company Limited, which, my lord, takes note of Tulok. Mar Apriyam, my lord. And the entire judgment is volume 5. 5, my lord. Only 5, my lord. 5. PDF page 2382. My learned friend cited ITC Limited, my lord, her ladyship Justice Ruma Pal's majority view.
Yes.
Lord, the minority view of my lord Justice Patnaik and Justice Bharucha. Lord, I'll just give the page numbers. My lord, it says exactly opposite, my lord. With the submissions, my lord, which I am respectfully canvassing for your lordship's acceptance. May I read or give the page para numbers, my lord?
Just the para numbers.
Para numbers, my lord. My lord, my note at 2G.
2D, no?
2G, my lord. It is filed not on record, my lord. It was uploaded yesterday in time, but could not reach your lordships, my lord. Lord, para 8, we have said Tikaramji is followed in following judgments, and one of them is, my lord, ITC, and dissent of Justice Patnaik and Justice Bharucha is para 189.
Page 705.
Page 189. It's a detailed discussion, my lord, on why my lord, majority is wrong, and therefore Tikaramji is wrong. My lord, it is page 1705 of volume 5. At my lord, 1705. At. Judgment starts at 1597, volume 5, but para 189 is at 1705. My lord's judgment, my lord, the Chief Justice's judgment regarding the RERA, that is Forum for People's Collective Efforts, which I referred to during the course of the day today, forum judgment, this is that judgment, versus State of West Bengal. Citation is 2021, volume 8, SCC 599. Lord, it is volume 5F, page 60.
16.
1660.
Page 60, my lord. Sorry, page 60. And paragraph number is 132, TO2, 132 to 133. Because 132 is in 3-4 paragraphs, my lord. There your lordships have considered all judgments on repugnancy by occupying the field. And my lord, your lordships are aware. My lord. So, my lord, these are my respectful submissions only. My lord, during the course of the recess, my lord, lunch hours, my lord, one fact, my lord, which I just highlight on entry 8. Give me the chart. My lord, I have prepared one chart, my lord. Just for a second, my lord, for a minute, my lord, it won't take more than. Lord, I was just wondering why two different expressions are used. Entry 8 list 2 says intoxicating liquors. Correct, Manoj?
Yes.
Entry 51 is taxing power of the state. It's a taxing entry. Therefore, what it says, alcoholic liquors for human consumption. It doesn't use the word intoxicating. Look, there are two reasons. First, I have already, my lord, assisted your lordship with the taxing entry being a taxing entry, you have to have the incidence of tax, that it would be at what
That
stage.
you had said, yes.
That I have already said. But second, look, there are certain products where there is alcoholic liquor, but it is not intoxicating. For example, cough syrup.
It is really speaking, the item that you are suggesting, it really speaking, not intoxicating, depends upon how many bottles you consume.
Yes, yes, the lordships are right, my lord. Anything in excess is poison, my lord. That's what people say, my lord. Even if you drink 5 liters of milk, you might die, my lord. But people are using it for intoxication purpose. But when we interpret the entry, my lord, we will go by the general use, not abuse. Your lordships are right. If you have 2 bottles of cough syrup, you get intoxicated, my lord.
Under the NDPS Act.
Correct? Yes.
For
The thousands of bottles are recovered, my lord, from people who don't have the license to sell, my lord. They are not pharmacy graduates.
They've been prosecuted under Prohibition Act.
Prohibition Act.
So you are saying that the word
Prohibition, this was
in alcoholic liquors for human consumption is used in entry 51 because firstly, it's a taxing entry and
So
therefore it has to
besides the
indicate the
taxing
basis
event.
of it. Yes.
And second, that there may be alcoholic liquors which are capable of human consumption, but may not have intoxicating effect. I mean, if used, not abused.
Yes.
No, these are my respectful submissions.
Thank you.
And I'll, on that, my lord, Tikaramji, I'll respond, my lord, day after. My lord, if
Yes.
this is in continuation and with consent of Mr. Dhruv, my lord, if my colleagues can have 5 minutes each, my lord.
Yes, yes.
It
of
would
course.
be, my lord,
Who will argue first?
all right.
What's your name? Mr. Umar Ahmed. Yes. Yes. 1 second. Umar Ahmed.
Only one argument, my lord, I left. Lord, sorry, my apologies. Lord, so far as synthetics 2 is concerned, my lord, which overrules Balsara.
Yes.
In taking the view that Balsara took the view that liquor includes all types of liquor, whether intoxicating, whether for human consumption, not human consumption, etc. Lord, synthetic says no. Intoxicating liquor for human consumption means something which is a beverage. Lord, I support that. Lord, there was one of the questions, my lord, which I'm duty bound, my lord, to answer, where according to me, going, my lord, reading, my lord, I can read, my lord, 4 or 5 paragraphs fully. What the learned Attorney General, the then learned Attorney General said, is not something at variance, except one statement that Balsara need not be overruled. Otherwise, my lord, the learned Attorney General also has said, my lord, what we have respectfully submitted. But the question was, so I'm, my lord, supporting synthetic too. But the question which was posed, my lord, because of Mr. Datar's article, that executive estoppel. Lord, we have, if your lordships would like to go into it, we have already filed judgments. There are 4 judgments which takes the view that a separate view can be taken by the law officer, my lord, because several things, my lord, because of lapse of time, society may have changed, law may have changed, there may be several circumstances. There are 4 direct judgments. Now, would your lordships like to go into that question?
Yes, Mr. Ahmed.
Because I have emailed a short note, my lords, or I can hand over a hard copy. I have a few minutes, but I just thought yes, my lord, it's on the screen, my lord. Lord, my submissions in brief pertain to the meaning of intoxicating liquor in entry 8 list 2. And my lords, broadly, Justice Chagla's judgment in the Bombay High Court in Balsara, which has not been shown, and a few reasons why the Supreme Court decision in Balsara may not be correct. My lords, I highlight that is because the state's argument really to bring in non-portable into entry 8 hinges on the interpretation put forth in Balsara. So, my lords, only few submissions with respect to why Balsara may not be correct on the proposition 8 rule, my lords. My lords, I will just very briefly go through these paragraphs, my lords. First 3 paragraphs, my lords, only highlight the fact that in entry 8 list 2, my lords, and I'm reading para 2, my lords, the noun which is liquor is qualified by an adjective that is intoxicating. The plain meaning of the latter being of alcoholic drink or a drug that can cause somebody to lose control of their behavior or their physical and mental abilities. My lords, this is a dictionary I've cited. And the antonym of which is non-intoxicating. That is, the consumption of the beverage does not lead to inebriation. And my lords, in paragraph 3, my lords, I've just highlighted that it makes no difference that the phrase meant for human consumption has been used instead and intoxicating has been done. And my lords, our understanding in Justice B.P. Jeevan Reddy's judgment, my lords, in para 4, I've just quoted the relevant para, my lords, to save time. This proposition is accepted, my lords. We'll just see para 10. I'll just read 2 lines in paragraph 10 of Bihar Distillery, my lords. It says, now coming to entry 8 in list 2, it does not use the expression alcoholic liquors for human consumption. It employs the expression intoxicating liquors, which expression is of course not qualified by the words human consumption. This is for the obvious reason that the word intoxicating signifies for human consumption, my lords. And that is, my lords, also, my learned Solicitor General has already dealt with Article 47, my lords. I've quoted that at the next page, my lord. The only reason I say that the same meaning which is there in Article 47 should be given. There's no reason why the same meaning should not be given. My lords, also, there are in paragraph 7, my lords, I have referred to the Constituent Assembly debates which were held on 24th November 1948. My lords, I've given the page reference. It was dealing with draft Article 38, my lords, which is now Article 47. And my lords, the whole discussion would show that it deals with intoxicating liquor, which is consumable as a beverage. And my lords, the importance there is they were dealing with this as a vice. They deal with all the religious minorities as to say everyone has a problem with alcohol spoiling a society, thereby showing it's purely consumable only, my lord. And my lord, I've just given the reference, my lord. Now, just very quickly to come to the decision in Balsara of Justice Chagla in the Bombay High Court, my lord, that has not been shown. I've just, for my lord's convenience, I've quoted it here. My lord, I just wanted to say that the Balsara Bombay High Court judgment, my lord, dealt with the Bombay Prohibition Act. There was a writ filed to the Prohibition Commissioner, my lords, for certain directions. My lords would see para 11. My lords was dealing with entry 31 of the Government of India Act 1935, which is, my lord, the predecessor entry to entry 8. My lords, I would just like to read in para 12, I've quoted page 439 of the Bombay High Court Balsara, my lords. And this is important. We have next to consider the scope of the words intoxicating liquor. In the first instance, liquor ordinarily means a strong drink as opposed to a soft drink. But it must in any event be a beverage which is ordinarily drunk. In the second place, the use of the word intoxicating in item 31, in contradistinction to the use of the word alcoholic in item 40A, as qualifying the word liquor, is very significant. My lords, 40A is now entry 51 list 2. Reading further, my lords, we may also point out that the white paper item 26, which correspond to entry 31, use the word alcoholic liquors, which have in Government of India Act been changed to so and so. Therefore, it is apparent that the class of alcoholic drinks, non-intoxicating drinks, are excluded by this entry. Thirdly, medicinal and alcohol, which are found in entry 40C, are neither liquor nor intoxicating, and therefore they are obviously excluded from the scope of item 31. My lords, I will not read the rest of this. This deals with a judgment of the US Supreme Court in Selzman. Only to say the last bit, Justice Chagla disagrees with the application of the US Supreme Court judgment, saying that only dealt with prohibition of noxious use. Because my note is only focused on the definition, my lord. My lord, now coming to the decision, para 13 onwards, my lord, Bombay High Court came up on appeal to this court, my lord, where Justice Fazil Ali, my lord, disagreed with the view. My lord, just want to add one thing. Justice Chagla used the plain words used in entry 8. The Supreme Court Balsara decision, as my lord will see, gives no reason why we should give a go by to that plain meaning, my lord. Because the ratio in Supreme Court Balsara, my lord, is in paragraph 39, 41, 42, and 44. My lord, I've quoted it. I will not read the whole thing, my lord. I just wanted to say in para 39, this court summarizes what the High Court held, my lords. In para 41, which is important, my lords, they say, thus, according to the dictionary, the word liquor may have a general meaning in the sense of a liquid, or it may have a special meaning, which is the third meaning, fermentation or distillation. The latter is undoubtedly the popular and most widely accepted meaning, and the basic idea of beverage seems rather predominantly to run through the main provisions of the various acts of this country as well as of America and England relating to intoxicating liquor, to which our attention was drawn. I just want to pause here for a moment. Justice Fazil Ali does notice that this is the predominant understanding. However, further it says, my lords, but at the same time, on a reference to these very acts, it is difficult to hold that they deal exclusively with beverage and are not applicable to certain articles which are strictly speaking not beverages. A few instances would also make the point clear. In the national, my lord, this is of the US, this is called the Volstead Act, my lord. They had defined liquor and intoxicating. This portion is relevant. In the National Prohibition Act, also known as the Volstead Act, the words liquor and intoxicating liquor are used as having the same meaning, and the definition states that these words shall be construed to include alcohol, brandy, whiskey, rum, gin, beer, ale, porter, and wine, and in addition thereto, any spirituous in malt or fermented liquor, liquids, and compounds, whether medicated, propriety, patented or not, and by whatever name called, containing 1/2 of 1% or more of alcohol, my lords will please mark, which are fit for use of beverage purposes. My lord, the Volstead Act, section 1, title 2 itself made it predicated on it being which are fit for use for beverage purposes. Having defined liquor and intoxicating liquor rather widely, the Volstead Act accepted denatured alcohol, medicinal preparations, toilet and antiseptic preparation, flavoring extracts and syrups, vinegar, and preserved sweet cider section for so and so. In some of these items, we have the qualifying words unfit for use for beverage purposes, but the heading of section 4 Volstead Act under which the acceptance are is exempted liquors. Well, I'll just very briefly, para 42 deals with the statute with the learned solicitor had shown. This is of UK. Justice Fazil Ali then gives the definition in 42. 44 is important. 44, coming now to the various definitions given in the Indian Acts. I may refer in the first instance to the Bombay Akbari Act of 1878 as amended. There are various statutes mentioned. I just want to point out these are all before the Government of India Act 1935. And then the portion after Bombay Act. Even if we exclude the American and English acts from our consideration, we find that all the provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor. The framers of the Government of India Act could not have been entirely ignorant of the accepted sense in which the word liquor has been used in the various excise acts of this country. And accordingly, I consider the appropriate conclusion to be that the word liquor covers not only those alcoholic liquids which are generally used for beverage purposes and produce intoxication, but also all liquids containing alcohol. It may be that the latter meaning is not the meaning which is attributed to the word liquor in common parlance, especially when that word is prefixed by the qualifying word intoxicating. But in my opinion, having regard to the numerous statutory definitions of that word, such a meaning could not have been intended to be excluded from the scope of the term intoxicating liquor as used in entry 31. My lord, in the next page, few paragraphs, I have dealt with each of these paragraphs as to why Balsara Supreme Court has not applied the law correctly. I'll just very briefly, my lords, I have a few minutes, I think I'll just. My lords, para 14, my lords, my submission is, as is evident, Supreme Court Balsara does not provide any reason for discarding the plain meaning of intoxicating liquor in favor of contextually limited statutory definitions in colonial legislations passed prior to the Government of India Act and a few legislations. Well, just to summarize, Manoj, para 15, I say, when Justice Fazal Ali deals with the Indian Acts, in paragraph 16 and 17, Manoj, I've cited case law to say that a court should not interpret constitutional entries with the help of statutory definitions. For instance, my lords, in Ahmedabad Municipal, the meaning of lands and building and entry 49, my lords, was being considered. And this court said to look at the entries in the 7th schedule, because my lords, they are contextual, they are limited, and they deal only with the object of the statute. Similarly, in para 17, my lords, there's a constitution bench judgment which was dealing with the meaning of industry in section 2J. Again, my lords, while dealing with that, said you cannot look at the judgments or the meanings which have been given to industry to see entry 52 of list 1, my lord, because that is a more limited definition. My lords, I've quoted them, I won't read them, my lords, and I've given the page references. My lords, paragraph 18, my lords, I now deal with the foreign statute which Justice Fazal Ali relied upon. And to say, even on a plain reading of those statutes, that conclusion could not have come, which has come in Balsara, my lord. Para 18, it is further submitted that SC Balsara's selective reliance on the definition of intoxicating liquor in the Licensing Consolidating Act was also incorrect. It did not consider the substantive provisions of the Licensing Consolidating Act 1910, which clearly indicate that an intoxicating liquor was nothing but a beverage, i.e. a substance actually meant for human consumption. My lord, in footnote 4, my lord, just for your convenience, I've mentioned all the sections.
We'll have to clearly open.
Malad, so Malad, in footnote 4, Malad, why I'm mentioning the National Licensing Consolidating Act 1910, why I mentioned, my lord had asked the learned solicitor when we were saying, Justice Fazal Ali notices the definition of intoxicating liquor in that. Apart from the fact, my lord, the judgment courts are wrong definition. It's not in the statute, but my lords, I'm saying that statute substantively deals with beverages which are a substance meant for consumption, my lords, in the footnote. Just for my lord's convenience, I've quoted all the relevant sections which clearly bring out that intoxicating liquor has to be a substance which is consumed as a beverage. I'm just saying, but with respect, Balsara Supreme Court did not see the whole act other than the definition, my lords. My lords, in paragraph 19, my lords, the learned solicitor has already dealt with these two, read the debates, my lords. So the law in England, which this court in Balsara dealt with, had a totally different view as to it had to be consumed. My lords, there are two new statutes which we were able to pull out. Paragraph 21, my lords, I'll read. Similarly, the Intoxicating Liquor Act 1927 of Ireland considered intoxicating liquor as a beverage. Illustratively, in the enactment, it was stated that the expression on license.
The word intoxicating.
Very well, my lord. My lord, there is another interesting act we found in para 22, my lord, which is the Habitual Drunkards Act, my lord.
That's okay.
My lord, I'll stop him. My lord, the only thing, my lord, just one last one. Synthetics, I would say. Sorry, I'm closing.
Synthetics.
My lord, synthetics preferred the view of Justice Chagla in Bombay in para 74. My lord, the reference order does not find fault in synthetics on this score of the disagreement with this court in view in Balsara, my lord. Just very grateful, my lord, for that.
Yes. To read that, Habitual Drunkard.
My lord, we found it only yesterday, my lord. I thought it was a very interesting
Not
statute.
amenable to any jurisdiction
Yes,
in lunacy. It is notwithstanding by reason of habitual intemperate drinking of intoxicating liquor, at that times dangerous to himself or herself, or to others, or incapable of managing himself or herself and his or her affairs.
I found it very interesting.
Drafted by a person who was intoxicated.
In this definition, one need not be intoxicated also.
I'm very grateful, my lord.
Ms. Taira Karanjawala.
May it please, my lord. Your lordships, I wish to address your lordships on the question of whether a notified order is required for a repugnancy to kick in under Article 254 of the Constitution. Your lordship, as far as this question is concerned, the first time these observations come into the jurisprudence is in Tikaramji. And as Justice Oak had observed, the actual question in Tikaramji was whether the UP Sugarcane Regulation of Supply and Purchase Act was repugnant to the IDRA. The Honorable Bench, having come to the conclusion that the State Act deals with the raw material concerned and doesn't deal with the product concerned, the raw material doesn't fall into the sweep of 18G, and therefore there is no repugnancy as the two acts operate in different fields. Of course, Learned Solicitor General has already addressed at length about how these observations are wrong. However, I'm on the second point of whether a notified order is required. Whether or not the first limb of the findings in Tikaramji is wrong or right, as far as the second limb is concerned, of whether a notified order is required, the Honorable Bench holds that even assuming sugarcane were an item falling within the sweep of 18G, there is no notified order and therefore there is no repugnancy. It is my humble submission that this was obiter dicta. This did not arise in the facts of that case, and therefore, and it is simply a 3-line observation without any discussion on the implications of such a finding on whether 18G was exhaustive in nature, although Tikaramji does notice the test of repugnancy, the 3 tests of repugnancy, in fact, including the test of whether the parliament has evinced an intention to cover the entire field. It does not apply this test as far as this question is concerned of whether the enactment of 18G itself is sufficient to denude the state legislatures, perhaps because it was not required to go that far, and the State Act was found to operate in a different field. Your Lordships, then in the 1990s, these same
Where does Tikaramji notice the 3-fold test of repugnancy? Can you just give us that para?
Yes.
Does refer
Yes,
to the third. Occupied field, they refer to specifically.
Yes, Your Lordship. Your Lordship, the discussion starts at para 27, where it notices under the Australian Constitution,
Para 27.
para 27, Your Lordships.
All right.
Thereafter, Your Lordships, in the 1990s, 2 judgments, Indian Aluminium Company versus Karnataka State Board and SAIL versus Union of India, which have been cited by the learned petitioner, they follow these observations, again, without any discussion on the scope of 18G. And it's notable that in both these judgments, the State Act concerned had the assent of the President and therefore fell within the ambit of Article 254, Clause 2. And therefore, again, perhaps a detailed discussion on this aspect was not required.
Have you dealt with it in your notes?
Yes, in my note, I've emailed a note. Yes. Your Lordship, at page 10, paragraph I, at the bottom, in SAIL, para 2 and para 23-24, both notice that the State Act concerned had the assent of the President. Indian Aluminium Company also, at paragraph 12, the PDF pages are given in the note, notices that this particular, the state enactment concerned had the assent of the President.
Yes.
Therefore, again, there is no detailed discussion on this aspect. These observations are then picked up by the Constitution Bench in Bailson Sugar, and then further in ITC, and then has been cited as the continuing jurisprudence. And in fact, the reference order says that the bench in synthetics, which was a 7-judge bench, and Tikaram was a 5-judge bench, doesn't consider these observations, but actually these observations were purely in the nature of obiter dicta. As learned solicitor has already pointed out, 2 constitution benches thereafter have doubted this proposition of law in Tikaramji and has classified these as a misapprehension of the legal position, both in Chulak and in Mara Prem. Your Lordship, as far as the test of repugnancy is concerned, from Tikaramji onwards to forum, there are 3 tests which have been recognized. Firstly, whether there is a direct collision between the Parliamentary Act and the State Act. The second, whether Parliament has enacted an exhaustive code or has evinced an intention to cover the entire field. And thirdly, whether the State Act has the State Act covers the same subject matter and seeks to set up a parallel mechanism as the Parliamentary Act. Your Lordship, in forum also, Your Lordships have given us guidance as to how one is to interpret test numbers 2 and 3. One of the tests that is given is the techniques used by the legislative draftsman, which include sections like whether the act is in addition to and not in derogation of. As learned solicitor already pointed out, section 31 of this act is unique because it only specifically says that that this act is in addition to and not in derogation of the central acts. The necessary implication being that it did intend to denude and derogate from any state enactments. In fact, the select committee on the bill specifically says that this clause was inserted ex abundante cautela to ensure that only the central acts were not derogated from. This is an important distinction from the decision in ITC, because in ITC, under the Tobacco Act, the relevant provision said that this act is in addition to and not in derogation of any other law for the timing in force. Our act, the IDRA, does not use the phrase any other law for the timing being enforced. And it is my humble submission that this was an important consideration which should have been noted in Tika Ramji if the analysis was that 18G is not enough to oust the legislative competence of the states.
Only it says that the application of other laws, which
Yes.
shall, the provisions of this act shall be in addition to and not save as expressly otherwise provided in derogation of any other sentence.
Central Act. It does not use any other law for the timing, Your Lordship. So therefore, the intention was to cover the field, different from the decision in ITC. Your Lordship, then the second submission on 18G notified orders, Your Lordships, is that 18G is not a bald provision. 18G subclause 2 specifies different circumstances in which the central government can issue a notified order. For example, price control, regulation of distribution, transport, consumption, possession by use of permits, prohibiting withholding the sale of a particular article, reserving, directing that a particular product that is being manufactured only be sold to a particular person under certain circumstances. So therefore, it is my humble submission that enough guidance has been given in that section. Also, unlike certain other provisions in the IDRA itself, the notified order under 18G does not need any further approval or any other step by Parliament for it to come into force. There are other provisions in the IDRA.
Fundamental point is that that the doctrine of repugnancy in the sense of an occupied field is not dependent on the exercise of the power by the...
It's not dependent on the exercise of the power, and in fact, by the executive, because the test of repugnancy is a test of parliamentary intention. As far as
it's an occupation of the field by the legislature.
By the legislature. As far as Parliament is concerned, 18G is the last word, Your Lordship, because the provision is such that it is exhaustive for that particular time. It can't give any further details because the premise is that it will deal with a changing situation. And therefore, as far as the legislative and parliamentary intention is concerned, 18G is itself enough to oust the competences of the legislatures. And in fact, it may be distinguished from other provisions under the IDRA, where in fact, for certain delegated legislations, the government has to go back to Parliament. For example, where under 11B, subclause 3, in case the central government is laying down any conditions for a particular industrial undertaking to be considered a small-scale undertaking, these requisites have to be laid before Parliament. If the management of a particular industrial undertaking is taken over and is extended beyond 5 years, that has to be laid before Parliament. And there are 4 such provisions in the IDRA itself. However, 18G doesn't require any further step by Parliament. And it's my humble submission that as far as the test of repugnancy is concerned, it is satisfied only by the enactment of 18G itself. Your Lordship, I'm very grateful for a patient hearing.
Lordships, my submissions have been emailed. If your Lordships have my written submissions.
Yes, sir.
Your Lordships, I will argue on the first and the third test of repugnancy, Your Lordships. So far as third test of repugnancy, which is being on the same subject matter, Your Lordships judgment in forum covers the subject, my lords. But my submission is that even so far as first test is concerned, which talks about direct collision, my lords. So here, there is a conscious legislative policy of not intervening in a certain manner, which learned solicitor said, forbearance. So the legislative tool, which legislative tool, how much has to be regulated, how pervasive has to be the regulation, at what periods the regulation has to exist, and when does it have to cease, my lords. These are all conscious legislative choices by the Parliament. So we have seen the evolution of ID Act and the nature of regulation, the exemptions. So it is a dynamic legislative choice which is being exercised by the Parliament. So here, if the centre is forbearing, not making a specific provision, not making a notified order, if that is considered to be an unoccupied field by the state, then it is in direct collision with the conscious legislative choice of the Parliament to abstain. Abstinence, it does not mean that I'm giving it up. I'm not exercising that choice, which is there with me because I have spread my coverage to the entire spectrum, which is right from production to production, supply, distribution, raw material, right from raw material to production, supply, and distribution. So my legislative coverage is occupied, and it is my legislative choice to decide how much do I want to, how pervasive my regulation will be. So this, Your Lordship, it also meets the first test. Your Lordship,
Yes.
so Your Lordship, I can have my written submission, my para 2, Your Lordship. In the present case, Your Lordships have my written submission.
Yes.
In the present case, the Parliament has legislatively covered the
Just a minute, just a minute.
The center is not issued.
That is also a choice. Cannot be harmed.
That cannot be.
Your Lordship, the second paragraph of my note. In the present case, Parliament has legislatively covered the field with regard to industries and production, supply and distribution of the products of such industries and their trade and commerce by means of RDI Act 1951. Section 2 read with 10, 11, 11B, 15, 16, 18G of IRDA in particular. It regulates not only the scheduled industries, but also the products of scheduled industries. That is to say, it covers all aspects of industries, right from procurement of raw material to trade and commerce of the finished goods. While regulating, the Parliament sometimes makes a conscious choice of not intervening given the market conditions or other factors. It is a conscious legislative choice in the interest of development of scheduled industries or production, supply, and distribution or trade or
While
commerce.
regulating, when you said the Parliament makes a conscious choice, you mean the government, right?
Please, Manoj. Yeah.
Government.
Please, Manoj.
The government sometimes makes a conscious
Yeah.
choice.
I'm sorry, Manoj.
Yeah, just go ahead.
It's a conscious legislative choice in the interest of development of a scheduled industry or production, supply, and distribution of products of the scheduled industry or its trade and commerce. Which legislative device or tool is to be used? How pervasive will be the regulation? And when it is to be regulated becomes the exclusive legislative choice of the Parliament once it has please, Manoj. Once it has spread its coverage to the scheduled industry, entry 52, list 1, and production and supply distribution of trade and commerce, which is relatable to 33. When there is a conscious exercise of legislative
Choice of
forbearance, then intervention by state legislature is directly in conflict with the regulatory regime made by the Parliament by law, since industrial plan or scheme of the Parliament, a scheduled industry or a class of scheduled industries, or scheduled industries in general will be directly be hindered or obstructed by a state law. For example, if Parliament is of the view that a sector needs only light touch regulation or no regulatory intervention at all, or if the Parliament feels that an intervention will be counterproductive, the Parliament will abstain from providing any regulation and will allow the market forces to play. In such a situation, my lords, it may be read as government.
When you are emailing it Sanskriti
I will,
today, just correct.
I'll make correction.
You can say central government instead of Parliament.
Please, my lords. In such a situation, if state law is made, then whole policy of abstinence or forbearance is defeated, and such law will necessarily be repugnant in terms of Article 254, my lords. So what I'm trying to say is, my lords, even the first test of direct collision is met, because here is a case of forbearance, and if the states start intervening because there is forbearance, it is defeating the policy of the central government, my lords. Yeah. And my lords, on this aspect, judgment of innovative, my lords, 2018 1 SEC 407, please, my lords, para 60, it says that the state law is defeating with the national plan and scheme of the IBC. So therefore, it was held to be repugnant. So, my lords, so far as second test is concerned, my lords, the same subject matter test is there, my lords. I would just want to add, my lords. Here, my lords, often there are judgments where the inquiry diverts to how much is occupied and what remains. Instead of focusing on the same subject matter test, one gets into this test of how much remains, because that test applies for distributive lists like entry 5423. So because there is a distribution of subject matter in list 1 and list 2, this examination may be necessary because how much field has been covered by the Parliament. But so far as the subject matter test, which is the third test, is concerned, my lords, this inquiry of micro dissection, whether this subject has been covered or not, that may not be a good test for 254, my lords, for the third test. And my lords, in this case, IDRA is a ragbag legislation, my lords. Entry 52, list 1, my lords.
It covers also entry 33 of list.
Entry 33, my lords, your lordship saw a price control also, which is entry 34, my lords. Prior to 2017, there was taxing provision also. So 84. So this ragbag legislation has too many rags, my lords. It's a comprehensive legislation. So that has to be kept in view while a state law is being seen, my lords. And my lords, the test in Tikaram which says occupied in fact, not mere possibility, my lords. The test is correct, but the application of test is incorrect. Occupied in fact only means Parliament has in fact made a law. There is no possibility of making a law. So if there is a law, the test is complete, my lords. And my lords, for the third test, my lords, there are two other aspects. If the lordships come to para 3 of my note at page 5, at page 3, my lords. Roman 3 and Roman 4. The Parliament may envisage a national level policy and a parallel law by state legislature cannot be
That was
permitted.
innovative, the
Please, my lord.
IBC case.
And my lords, the fourth aspect is aspect of uniformity. My lords, a concurrent list has those subjects where uniformity may not be mandatory like list 1, but desirable. So when Parliament makes a law, keeping the intention of having a uniform law for the entire nation is concerned, my lord, then variations by the state, my lords, they will have to be read with lot of circumspection, my lords. And my lords, para 5 of my note, my lords. It is submitted that the most vital subject fields which could not have been left to the state provinces and were all of all India import were put in list 1. These are subjects where uniformity was imperative and there was no room for any variation as per state needs unless entry itself provided for that. Those subjects where uniformity was desirable with room for variation or modification by legislation for states, if need be, were put in list 3. This is also reflected from the Constituent Assembly debates dated 4th November 1948 when the draft constitution was being discussed. Dr. Ambedkar said, there is another special feature of the proposed Indian Federation which distinguishes it from other federations. A federation being a dual polity based on divided authority with separate legislative, executive and judicial powers for each of the polities is bound to produce diversity in laws and administration and in judicial protection. Up to a certain point, this diversity does not matter. It may be welcomed as being an attempt to accommodate the powers of government to local needs and local circumstances. But this very diversity, when it goes beyond a certain point, is capable of producing chaos and has produced chaos in many federal states. One has only to imagine 20 different laws. If we have 20 states in the union of marriage, divorce, of inheritance, of property, family relations, contract, torts, crimes, weights and measurement of bills and checks, such, my lords, I will leave that. And such a state of affairs not only weakens the state but becomes intolerant to the citizens who moves from state to state only to find what is lawful in one state is not lawful in another. The second paragraph, my lords, care is taken to eliminate all diversity from laws which are at the basis of civic and corporate life. The great codes of civil and criminal laws such as civil CPC, Penal Code, CRPC and the Evidence Act. My lords, I will not read any further. Only the last 2 lines so that necessary uniformity can always be preserved without impairing the federal system, my lords. So, my lords, uniformity is one factor which is relevant while applying the third test, my lords. Para 6 subjects such as criminal law, criminal procedure, marriage, divorce, adoption, transfer of property, contracts, bankruptcy and insolvency, prevention of cruelty to animals, legal and medical and other professions are few such illustrations wherein a uniform law has been laid down by the Parliament. These laws do no doubt have certain state amendments, but Article 254(2) specifically takes care of such a situation wherein variation, modification, which are required, are, my lords, assent can be taken by the President, my lords.
Thank you, Sanskriti.
I'm obliged to do.
So we'll give you 10 minutes.
Chiefs have been very kind, my lord. I'm really grateful.
Thank you. No, thank you all three, Omar, Sanskriti and Taira. Thank you very much. So we now have 1 hour is too much. I'll tell you why. Our schedule is we have to wrap up by lunch on Thursday, both sides. So we'll have to give them 2 hours. We will have to wrap up by lunch on Thursday. So we'll have to give them time to make the rejoinder.
But may not be possible with you, sir. By lunch, I cannot, perhaps I'll try my best, but it's not.
But now we have seen, you have to now make your
the response may take time, no?
We'll
As I said,
I think what we suggest is
every day.
that you circulate your note.
I have already filed my written submissions,
All right.
but I'll take at least 45 minutes, if not an hour.
We'll read your submissions.
Yes.
We'll read your submissions.
Yes.
We'll give you 10 minutes and 10 minutes to
My
Mr.
lords, 10
Bhandari.
minutes would not be sufficient. My lords, just a minute. My lords, 10 minutes would not be sufficient because I'm representing the industry and industry is the,
That's all about
at the
the-
receiving end.
I know, but this
Because-
Solicitor General.
No, I know, my lords. My lords, at least 45 minutes I will
We
require.
can't do 45 minutes, absolutely. We have to,
My lords.
look, we will give them, I'll tell you what we'll do is, we will give them 2 hours for the rejoinder. 2 hours for the rejoinder is very fair for them. So 11 o'clock to 1 o'clock, we'll give them for the.
My lords, half an hour would be too.
So-
My lords, if
Then what
I'm
we'll do is we'll
repeating-
give them 2.5 hours for the rejoinder. We are our conscience is satisfied. We have heard you all sufficiently. So half an hour between all of you, 10:30 to 11. 11-1 is the rejoinder, and we can wrap up. One rejoinder, no, not more than one rejoinder. I think we have to, all things have to end.
They have agreed, not for one rejoinder, Mr.
Yes.
VIVEK is giving that.
Yes.
Right.